Does it look like a peaceful protest? I like that the federal officers have a pop-up tent. That's great. I'm not going to play the whole several minutes, but you get the point, right? This is chaos on the ground. So it's never been required for any of the roughly half the presidents who have deployed the National Guard that it was in the entirety of the federal government that was at risk. But that's Judge April Perry, the genius, the legal genius that is Judge April Perry. That's her standard. All right, let's get to John Sauer's argument on the merits here. Under Rule 23 of the court's, an applicant for a stay of a temporary restraining order has to show a likelihood of success on the merits, reasonable probability of abstaining certiorari from the Supreme Court, and a likelihood of irreparable harm. The federal government, John Sauer argues, is likely to succeed on the merits. The federal government likely to succeed in vacating Judge April Perry's order. The president's invocation of 12406 was lawful and consistent with a long historical tradition, tracing back to President Washington's response to the Whiskey Rebellion of relying on the armed forces and the militia to assist in responding to violent resistance to federal law enforcement. The decision on whether to call up the National Guard in order to protect federal personnel and property is for the president to make, not the state of Illinois or a federal district court. And regardless, Judge April Perry's cramped construction of Section 12406 and its disregard for the sworn declarations of federal officials are indefensible. The decision whether to call up the National Guard is committed exclusively to the president. As a threshold matter, both the statutory language and historical tradition make clear that the president's decision whether to federalize the Guard is not subject to second guessing by the state of Illinois or a federal district court. Section 2406 provides that whenever any of three circumstances is satisfied, the president may call into federal service members and units of the National Guard in such numbers as he considers necessary. He may invoke that authority when there is a rebellion or a danger of rebellion against the authority of the United States, or when the president is unable with the regular forces to execute the laws of the U.S. That statute specifies that orders for these purposes shall be issued through the governors of the states, but as the term orders makes clear, the president's determination to call up the National Guard is not a request, it is a command. The president has express authority to call into federal service the National Guard, after which the guardsmen serve under the command and control of federal military officials, and ultimately the president as commander-in-chief. Section 12406 is one of a number of provisions in current law that implement the militia clauses in the Constitution. The Constitution invests Congress with the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. That's all under, of course, Article 1, a congressional power, as well as to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States. Accordingly, when the president calls up the National Guard for federal service, pursuant to an express authorization of Congress, his authority is at its maximum. In other words, it's combining the delegated militia authority of Congress and the president's commander-in-chief authority all in one. The president's authority is at its maximum, for it includes all that he possesses in his own right as commander-in-chief, plus all that Congress can delegate. And so it is supported by the strongest of presumptions and the widest latitude of judicial interpretation. This Supreme Court long ago established that the president's exercise of the authority invested in him by Congress to call up the militia is committed to his exclusive discretion by law. That's Martin v. Mott from 1827, that War of 1812 militia serviceman case. In Martin v. Mott, a member of the militia of New York challenged the penalties imposed on him by a court-martial after he refused to comply with orders to report for militia service as part of the War of 1812. President Madison had called the state militia into federal service. pursuant to a 1795 law providing that whenever the U.S. shall be invaded or be in imminent danger of invasion from any foreign nation or Indian tribe, those nice Indians, dances with wolves, Indians, it shall be lawful for the President of the U.S. to call forth such number of the militia most convenient to the place of danger or scene of action as he may judge necessary to repel such invasion. This Supreme Court refused to entertain the contention that the president has misjudged the danger of such an invasion, explaining that the authority to decide whether the exigency has arisen belongs exclusively to the president, whose decision is conclusive upon all other persons. That conclusion, the Supreme Court explained, necessarily results from the nature of the power itself. To be effective, the president's authority to call up the militia must receive unhesitating obedience from his military subordinates, consistent with command of a military nature. The Supreme Court also emphasized that the 1795 law confided the power to call up the militia to the executive of the Union as commander-in-chief, and thus necessarily constituted the president himself as the judge of the existence of the exigency in the first instance. The same principles apply here. At bottom, the plaintiffs, Chicago and Illinois, seek to use this lawsuit to second-guess the president's judgment that recent and repeated acts of violence targeting federal facilities and personnel in Illinois warrant calling up the National Guard, including because the violence has left the president sufficiently unable to ensure faithful execution of the federal law. Like the 1795 law at issue in Martin, Section 12406 makes clear that Congress has granted the authority to decide whether the statutory prerequisites are satisfied exclusively to the president. Judge April Perry misunderstood Martin to have turned on the identity of the plaintiff, a militiaman challenging the federalization, and on the fact that the case involved a foreign invasion rather than a purely domestic controversy. The Court of Appeals agreed with that take. But nothing about the rationale of this Supreme Court's decision turned on or was limited to those particular facts. The Supreme Court's reference to the nature of the power at issue meant the president's authority to call the militia into federal service under his command, an authority that would be substantially undermined if subordinate officers or soldiers are pausing to consider whether they ought to obey or are scrupulously weighing the evidence of the fact upon which the commander-in-chief exercises the right to demand their services. Those concerns apply equally where, as here, the president calls up the National Guard to address violent unrest in a state, and elected state officials ask a court to reweigh the evidence of the facts upon which the commander-in-chief exercised his authority. And to the extent that Judge April Perry believed that modern developments in the political question doctrine have drained the force out of the Martin Supreme Court decision, the court was mistaken. Martin and the many similar cases following it reflect the president's singular role in our constitutional system. The president was acting here as commander-in-chief, calling the National Guard into federal active service pursuant to express authority vested in him by Congress under the militia clauses. The effect of his decision was to transfer the operational command of 700 guardsmen from state officials to the commander of U.S. Northern Command. The president was responding to repeated acts of violence that threaten the safety of federal personnel and property, concerns that implicate the president's inherent Article II authority to use troops for the protection of federal property and federal functions. A federal district court lacks not only the authority, but also the competence to wrest control of the military chain of command from the commander-in-chief and to adjudicate whether Illinois, the governor of Illinois, rather than the president, should be in ultimate command of particular guardsmen after the president has called them into federal service under 12406. Even outside the military context, this Supreme Court has repeatedly emphasized that how the president chooses to exercise the discretion Congress has granted him is not a matter for judicial review. When a valid statute commits a decision to the discretion of the president's exercise of discretion is not subject to judicial second guessing. That principle applies here, notwithstanding that Section 12406 does not expressly state that it's the president who determines whether the specified criteria are met. The statute vests the president, not the state of Illinois or a federal court, with the sole authority to decide whether the specified criteria are satisfied. The Ninth Circuit recently concluded that federal courts may review the president's determination under Section 12406, but that such any review must be highly deferential. So, of course, John Sauer would disagree. John Sauer would say the federal courts have no review authority. The Ninth Circuit said, well, we have some review authority, but we're supposed to be highly deferential to the president. But even in that view, a court may at least review whether the president's judgment reflects a colorable assessment of the facts and law within a range of honest judgment. In other words, is there more than zero evidence to support the president's judgment? If there is, you have to defer to him. It's not a preponderance of the evidence standard. It's not a beyond any reasonable doubt standard. The facts have to support the president beyond any reasonable doubt. It's the reverse of that. Anybody opposing the president's judgment would have to be able to show beyond any reasonable doubt that there were no facts to support the president's conclusion. Applying that standard, the Ninth Circuit determined the federal government was likely to succeed in showing that the president had a colorable basis for invoking 12406.3 to federalize members of the California National Guard in June in response to mob violence in Los Angeles. The Seventh Circuit here agreed with the Ninth Circuit that a court may review whether one of the statutory predicates exists for federalization and that such review must be deferential, although the Seventh Circuit declined to say precisely how deferential. Both courts were mistaken to conclude that a federal court may review the president's judgment at all. Bam! This is the correct answer. Martin v. Mott, the Supreme Court decision, forecloses such review entirely. The federal courts have not a damn thing to say about any of this. And the subsequent relitigation of this issue in judicial districts across the country demonstrate the ills that Martin was trying to protect against. The Ninth Circuit apparently viewed Martin as having been qualified by this court's later decision in Sterling, but Sterling only confirms the president's judgment is not reviewable. In that case, a federal court had enjoined a state agency from implementing orders to limit oil production. The governor of Texas had declared martial law in parts of the state during the litigation and had responded to the injunction by ordering the state militia to shut down oil wells operating in violation of production limits. The federal court then enjoined the governor's order. This Supreme Court upheld the lower court's determination that the governor's order establishing production controls were reviewable and were unconstitutional. But at the same time, the Supreme Court emphasized that when the executive is appropriately vested with the discretion to determine whether an exigency requiring military aid has arisen, the executive's decision to that effect is conclusive. And the court attributed that proposition to Martin, which it cited and quoted approvingly. The exercise of judicial review in Sterling itself did not violate that principle, the Supreme Court explained, because the case concerned the lawfulness of the governor's production controls, not the governor's antecedent decision to call up the militia in the face of what the governor found to be an insurrection in the state. In other words, the analogy here would be, what if the immigration laws being enforced were unlawful? Well, then the calling up the National Guard to protect the enforcement of those unlawful immigration laws would be itself unlawful. That's what happened here in this Texas case of Sterling. The governor had put in production limits. That order was unlawful. So calling up the National Guard to enforce that unlawful order was itself unlawful. But no one is contesting that the immigration laws being enforced here in 2025 in Chicago, the immigration laws are clearly lawful, so enforcing them is clearly lawful, and calling out the National Guard to enforce lawful laws is exclusively within the discretion of the president and non-reviewable by the courts. This case is controlled by Martin and its progeny, the cases that followed. Chicago and Illinois attacked the president's determination that the circumstances in Illinois warrant federalizing the National Guard, precisely the question that Martin held to be committed exclusively to the president's discretion. Martin and Luther and Sterling, cases that followed Martin. If the president's decision to call up members of the National Guard were amenable to judicial review, any such review would need to be highly circumscribed for an additional reason not addressed by the Seventh Circuit. The president's determination cannot be challenged under the Administrative Practices Act. The plaintiffs have instead sought to assert a violation of Section 1206 on an ultra vires basis, that it's simply beyond the law, that the president is violating a statutory prohibition by activating the National Guard here. Even assuming, for argument's purposes, that actions of the president could be reviewed on such a basis, this Supreme Court has recently reiterated that non-statutory ultra vires review must be strictly limited in order to prevent plaintiffs from circumventing the limits Congress built into the APA. Ultra vires review is available only when an agency has taken an action entirely in excess of its delegated powers and contrary to a specific prohibition in a statute, and only when the plaintiffs otherwise lacks any meaningful and adequate opportunity for judicial review. The Supreme Court has thus compared ultra vires review to a Hail Mary pass that rarely succeeds.